All right, are we ready to go?
Yep, we're ready.
All right, Colby, if you want to go ahead and start recording.
Good to go.
Well, welcome everyone. My name is Jacob Harper. I am the Media and Communications Manager at the Department of Energy and Environment. Welcome everyone. Today we're going to hold the third CPP continuing planning process and anti-deg implementation methodology stakeholder work group. And as I said, my name is Jacob Harper. As we did already before this meeting, we have Colby modifying people's names in the background, just running through some housekeeping stuff here. Most of you are familiar because we did this a few weeks back, but if you would like to chat or make a comment or start discussion, go ahead and please use, if you can, that chat or raise hand feature or contact one of us and say that you'd like to be unmuted. If you're an approved stakeholder representative, please go ahead and provide your phone number if you're using a phone to call in. I don't think we had that problem this morning. And for the purposes of this meeting, stakeholder representatives have commenting privileges and the public does not. I'm going to go ahead and do some introductions for the DEQ facilitators and staff. This morning we have Dr. Bob Blands. He is the Office of Water Quality Associate Director. We've got Brian Leemans, who is the Senior Operations Manager. Kerry McWilliams, who is an NPDES Engineering Supervisor. Dr. Zachary Carroll, he is an NPDES Permanent Engineer. We have Faison Khan, NPDES Permanent Engineer, as well as Shane Byram. Jessica Sears, who is a NPDES Engineering Supervisor. We've got Joe Martin, who's the Planning Branch Manager, and Mary Barnett, who's an Ecologist Coordinator. I think we have a list of stakeholders that possibly could be shared up on the screen. I think you should know who you are. And I have a final note to the viewing public. Viewing public will be muted for the duration of this meeting. And if you have comments or questions, please go ahead and send an email into the Office of Water Quality at cpp-antideg, ANTIDEG-comments. That's plural comments at adeq.state.ar.us. That's cpp-antideg-comments at adeq.state.ar.us. And now I'm going to go ahead and turn it over to Brian Leemans, Senior Operations Manager for the Office of Water Quality.
Thank you, Jake, and also welcome to the stakeholders and the staff to our third meeting for our continuous planning process, CPP, and anti-degradation implementation methodology, or AIM, AIM. We appreciate the involvement of everyone, the stakeholders, especially we know you've got a lot of other duties with your other job, and it's always a big ask to take part on one of these stakeholder processes. Thanks to the DEQ staff that has spent many hours working on these plans, going through them back and forth over and over, as we have alluded to in the last meetings. Just to recap where we were last time, we had two meetings on June 22nd. The first meeting was a general overview. Kerry McWilliams and Zachary Carroll both presented the basics of our CPP and also our proposed anti-degradation implementation methodology. They discussed that the two plans are elements of our Clean Water Act required program duties. They're outlined by the CFR. The CPP is not a new document. It's been around many years, and in fact hasn't been updated in about 20 years. So it's really about time we go through that document and provide an update. Also, the anti-degradation policy and the AIM, which we're proposing. The policy has been in our Rule 2 for many years as part of our water quality standards. The policy is required by the Clean Water Act, but we had not, up until now, had not had in place or proposed to be in place a written implementation methodology, which is what we're proposing now. So last time they discussed the general content and the purpose of these plans. After going through that, we had an open forum discussion, and that concluded the first meeting. In the afternoon session, Carrie dove into many more details of the existing CPP, and she discussed how that's a technical manual that generally guides our procedure and our policy for permitting drafting and decision making, but also it provides a basic framework for our other programs, enforcement, compliance, and also guides various items like rule changes or revisions. Carrie went through this CPP, and she discussed the general reorganization, which is a big part of the current proposal. And she also went through some of the changes that were to be made to the CPP, which we don't find to be too many, but she high-pointed some of those which may affect stakeholders. So after concluding that discussion, we had another open forum, which leads us to really where we are today. This meeting today is the intent is to dive into greater details with the anti-degradation implementation methodology, which we're proposing. We're going to present a slideshow to overview what we're proposing for now. And after going through that, we are going to open another open forum. One thing we mentioned in the last meeting was that we asked everyone, sort of as a homework assignment at least, to go through the CPP as we had discussed it on June 22nd, and that we would open some time to specifically discuss CPP topics. We are going to open that and offer that today, but what we're proposing now on our schedule is to include that in the open forum, which we'll open after we go through the slideshow, the anti-deg implementation plan. So with that, we will be having a final meeting on July 22nd. We plan to touch back on some of the high point issues from the first 3 meetings, and we expect another open forum. We're going to really provide a great amount of time for the stakeholders to bring forward any issues or items that we need to continue to discuss. But we are open to other ideas, or if anyone wants to send us topics for the final meeting, please do so through the email that we've provided. But at this point, I'm going to turn it over to Zachary Carroll, and he's going to go through our presentation on the details of the anti-deg implementation methodology. So Zachary, go ahead.
All right. Okay, so I'm going to give a brief presentation here. Kind of give a section by section overview of our draft anti-degradation implementation methodology. Then we'll have an opportunity for general questions, and then kind of an open discussion on each section. And probably both this presentation and our discussion, we'd like to start with section 2, because section 1 is just the definitions, and we found it's very easy to get bogged down in those and not really get into kind of the meat of the document itself. So section 2 here, this is the introduction, the overview of how the anti-degradation plan is going for Arkansas. I think you've already seen this slide before, but go over it real quick again, that the policy is in the APC Rule 2, and that defines our 3 tiers of water and the exceptions for lowering of water quality and the high quality water. And the implementation procedure, which is what we're going to be discussing today, is something that's referenced in the CPP, but it's currently our plan is to put it out as a standalone document that can be independently updated. So then moving on to section 3 here, this lays out the tier protection levels and a little more detail than what's in the policy. So tier 1s are existing use protection. This is kind of the baseline protection for all parameters of all waters of the U.S. that the existing uses are going to be maintained and protected. And then the tier 2 is high quality protection, and that applies where the existing baseline water quality is better than whatever our minimum criteria is for preserving the existing uses. And then finally, the tier 3, these are our outstanding resource waters, which this applies to the water bodies that are specifically designated as such in Rule 2. So have a little flow chart here just for how you would look at, say, if there's a water you want to know, well, what tier of protection applies to that water? So first you'd look at, is this water body listed in Rule 2 as one of these specific outstanding resource waters? And if so, then it's tier 3. Otherwise, it falls in this parameter by parameter classification. And so you look at each parameter and say, well, is that parameter attaining water quality standards? If not, then it falls into tier 1. If it is attaining water quality standards, then it would fall into tier 2. And in section 4, this gets into a little more detail on how the different tier protections apply for anti-degradation purposes. So as I mentioned previously, the tier 1 and tier 2 evaluations are done on a parameter by parameter basis. So it's very possible for a stream to require a tier 1 evaluation for some parameters and a tier 2 evaluation for the other parameters. Whereas the tier 3 evaluations, that is done on the entire water body. So going to each tier now in a little more detail. The tier 1, as I said before, this is our existing use protection. And this would apply to the parameters that are not attaining water quality criteria. And this is essentially the same level of protection that is currently done in NPDES permits here, that the discharge cannot cause or contribute to any impairment of the water. It's going to preserve all those existing uses. And for waters that fall into this class, there is no social or economic analysis required. However, they would have to meet fairly stringent discharge standards because what's coming out at the end of the pipe would need to be as good or better than the existing water quality so as not to be causing or contributing to the existing impairment. And tier 2, these are the high quality waters here, the high quality parameters, I suppose. So this would be for the parameters that are attaining water quality, the water quality criteria. The exception would be if they're designated as an outstanding resource water, then they would fall under tier 3 instead. And we'll get to this a little bit later when we get to section 8, but there are some situations where using a non-significant increase in the pollutant load, you would not have to do the social and economic analysis, but if you're using greater than 10% of the assimilable capacity, then that would be required. And also at bare minimum, a tier 2 protection always requires that tier 1 protection is ensured, that in no situation would we allow a high quality water to be lowered so much that it causes an impairment. The tier 3, these are outstanding resource waters. These are specifically designated in Rule 2. And for these waters, we want them to be preserved for the future. So there is no permanent increase of parameter loading allowed to these waters. You may be able to have a temporary lowering of water quality, and that would be subject to an anti-degradation review. Then sections 5 and 6 here, this gets a little more about how protection is assigned into section 5. This is largely a summary of section 4, but a little more focused on which waters receive each tier of protection. And then section 6 gets into how the tier protection levels can be revised. This is primarily through changes to Rule 2 or the 303D list. That's their list of impaired water bodies. Section 5 gets into what activities are eligible for anti-degradation review, and it more or less boils down to that any newer expanding wastewater discharge would be subject to an anti-degradation review. There are some special cases, notably thermal discharges. Those have a special procedure that's described in Rule 2 and the Clean Water Act. General permits, as far as actually putting anti-degradation, the implementation plan into the general permits, that would be addressed within 5 years of approval of this document. However, in the meantime, coverage for newer and expanding facilities may still be subject to anti-degradation reviews on their individual coverage, starting from the effective date of the anti-degradation implementation methodology. Additionally, we're going to leave it open that we may end up developing a general anti-degradation review for small domestic dischargers. This is something that I think Missouri had been doing, and they were saying it had worked out very well for them. The idea being this is fairly similar to what we already have in Rule 6 for these technology limits for small dischargers, that there may be some sort of best practicable technology that if the small dischargers can meet that, they may not need to consider other alternatives. So then Section 8, this gets into exactly how these anti-degradation reviews pan out here. And the really important thing that's going to change with this is that once this anti-degradation implementation becomes final, then the applicants are going to need to start coordinating with us before applying for an NPDES permit. This is really important because parts of this anti-degradation review need to be considered during the design phase of the project. Also, the applicant will have an opportunity that they can try and submit an analysis of no degradation, temporary degradation, or non-significant degradation. They believe one of those conditions is applicable, because if that's the case, then there's some parts of the anti-degradation review that you wouldn't have to do. So typically what we think this would look like here is that you start off with the applicant requesting some preliminary limits for the facility. And at that point, they could submit an analysis of their degree of degradation if they wanted to. Otherwise, we would determine that. If they submit an analysis, then of course we would review the analysis and make sure we think it makes sense. And if we determine that there is significant degradation occurring, then they need to go ahead and do an alternatives analysis and a socioeconomic analysis, and get into exactly what those are a little bit later. And then you kind of get to the permit application step after that. And in many ways, the anti-degradation review just becomes part of the permit application. It's subject to all of the same public notices, public hearings, can be appealed. It's pretty much, from that point on, it's handled very similar to the way that the NPDES permit is handled. All right, so I mentioned earlier we're going to go through a little more detail on how do you determine if it's significant versus non-significant degradation. So for non-significant degradation, that would be use of less than or equal to 10% of the assimilable capacity. And we anticipate that this is generally only going to be possible in the larger rivers of the state. So to demonstrate this, you would also need water quality data, which fortunately we do generally have monitoring stations on the larger rivers. So we have water quality data available for a lot of those. If there is no available water quality data, then the burden is on the applicant to collect that water quality data. And if you can prove that you're using less than 10% of the total assimilable capacity, then there is no alternative analysis or socioeconomic impact review required. On the other hand, you could end up with significant degradation. And there's two ways this could happen. One is that if you go ahead and look at the water quality data and do the calculations, and it turns out using more than 10% of the assimilable capacity, then that would be significant degradation. Or if the applicant just thinks that there probably is going to be significant degradation, then they don't necessarily have to evaluate water quality data. They can just say that, well, I think there's going to be significant degradation here. and go straight into their alternatives analysis and socioeconomic impact review. So here's a diagram here trying to make this non-significant degradation a little more clear. Hopefully I can explain it better here. So we have the baseline existing water quality up here. It's high quality water. This is going to be better than our water quality criteria, which this is our bare minimum to preserve the existing uses. So in no case would we allow something to go down into this red area here. And the difference between these two is the total assimilable capacity, which is represented by the green and blue bars combined together here. And so non-significant degradation would be only using this little green bar here. You can only take 10% of that assimilable capacity. If you ended up in this blue bar here, that would be significant degradation. So I'm going to try to run through an example with some concrete numbers here. It's going to be a little bit non-intuitive because, as you can see, the small numbers are on top instead of on bottom, and the large numbers are on bottom. So the existing water quality here, we're going to say that's 0.5 milligram per liter, and we're going to be looking at ammonia as our example parameter. And then our minimum water quality criteria here, or I guess maximum in this case, would be 3.2 milligrams per liter. So in no case would we ever want this water to be greater than 3.2 milligrams per liter of ammonia. So then our buffer zone here, which is our total assimilable capacity, I say that's the difference between our maximum criteria here and the baseline background concentration. That's 2.7. And then for non-significant degradation, you could only use 10% of that, which works out to be 0.27 milligrams per liter. So say, for example, we have a facility that's putting out 500,000 gallons a day, which when converted to cubic feet per second works out to 0.77. And we'll say that they've 5 milligrams per liter of ammonia. And then we'll say they're going into a pretty big river here that's got 700 cubic feet per second. And the background concentration, you're gonna use the same numbers as in that chart previously, is 0.5 milligram per liter. Now this is something that's from our continuous planning process. The mixing zone policy is that for a large river like this, you only get to use 1/4 of the flow for the mixing zone. So this is 175 cubic feet per second is going to be what the allowable mixing zone for this river is. Then, as I mentioned previously, the water quality criteria here, we're going to say that is 3.2 milligrams per liter. So our assimilable capacity is our difference between our water quality criteria and the background concentration. That works out to 2.7 milligrams per liter in this case. And so for non-significant degradation, you cannot use more than 10% of that, which means you cannot increase the ammonia concentration in this water by more than 0.27 milligrams per liter. So if we do the math here to determine the concentration at the edge of the mixing zone, what this works out to is the flow of the river times the concentration in the river, plus the flow of our point source times the concentration in our point source, and then you divide it by the sum of the two flows. And in this case, it would work out to 0.519 milligrams per liter. So we can compare that to the background concentration. How much have we increased it in the river? And it comes out to being 0.019 milligrams per liter. And in this case, that is less than our 10%. So that would be determined as non-significant degradation. If it had been more than this number, then it would be significant degradation. I think I'm going to pause it here a little bit just to make sure, I know there's a lot of math here, and I think this is, when we did our focus group earlier, I think there's a lot of confusion about this topic. So I wanted to make sure that so it was clear with everybody. If you had any questions about, particularly about this non-significant degradation part here.
If you have any questions, raise your hand or put it in chat. We got questions coming in. Russell. Oh, I'm sending your request on mute, Russell.
I'm sorry. Zach, question about cumulative cap, because over succeeding permit cycles, if you're using 10% every time, you're eventually going to use up all the assimilative capacity. And I don't think the draft had any mention of cumulative cap in it.
Okay, yeah, I think it was our intent that this would be a cumulative process here, that if somebody has done one of these anti-degradation reviews, then that would be, if somebody had already used part of this assimilative capacity, then that would be considered already used for anybody who, say, were to come in immediately downstream of them or something. Brian can correct me if I'm wrong.
Yeah, Zach, can y'all hear me? Am I on?
Yes.
Okay, that is the tentative plan, that if someone uses one of these 10% insignificance determinations, that would stay not only with the permitting file, but with the 208 water quality management plan. So we can track that as needed. We really don't anticipate, as Zach said, we don't anticipate a lot of people being able to use the 10% method, because it may only be available in large rivers when you have a lot of benefit of background flow. But
Okay,
we do have the
thanks.
capacity. We do have the capacity to keep up with that information.
Colleen?
Am I unmuted? Hello?
Okay, I can hear you now.
You guys are kind of slow on the unmuting. We're getting, at least I get a message that says I can't unmute myself, that the host has to do it.
Yes,
Correct?
ma'am. Yes, ma'am.
So, okay, so if there's a delay, it's you guys need to be the ones to unmute stakeholders. So I had sort of the same question as Russell. I think there should be a mention of how that's going to be accounted for and kept track of in the methodology, instead of just saying, well, it's our intent to do that. Both as to the 10% that's used, and if it's determined to be an insignificant, less than 10%, then that needs to be tracked as well. I understand that it's unlikely it's ever going to add up to make a difference, but it could, conceivably. The second thing, I sent a chat message to, I think it was supposed to go to Colby. Are you guys getting those?
I never received a chat message from you. I received chat messages from other people, but I have not received one from you.
I'm not sure why it didn't go through then, but to start with, I tried to connect this morning by the link that's on the web page, and that gets a message that says invalid meeting ID. So there may be people that are trying to connect to this meeting who aren't able to. So could someone try to this morning address that, please?
We will look into it.
Thank you. So what about, how can you change the language of the methodology to make it specific about how you're going to track what part of the assimilative capacity has been used by each permit application or each permit that's granted?
We'll consider the comment and make adjustments if needed.
Okay. And then, I don't know, are you going to talk some more about what flow is used on the significant or non-significant degradation determination?
Oh, it's the critical low flow. That's in our continuous planning process, at least, if not, it may be in the anti-degradation methodology. I'm not entirely certain. I can't remember offhand. The 7Q10, the critical low season flow.
Thank you.
I guess if we don't have any other questions on the non-significant degradation, I'll move on to the rest of the presentation then.
Yes, please, Zach, go ahead.
All right, so next part here is the alternative social development and economic analyses. So the alternative analysis, this is looking at other alternatives that might be able to reduce the environmental impact. For a municipal source, that's typically going to be more like improved treatment. For industrial sources, there may be some other things they can do to reduce the amount of pollutants coming out. Then the social development analysis, this is the justifying that the degradation is important, that the water is going to be degraded, however, it has these societal benefits that justify the degradation. And then the economic analysis, this is looking at the, particularly that in this alternatives analysis, you come up with these practicable alternatives here. And so then in the economic analysis, you do a cost comparison of these practicable alternatives. And we have come up with some guidance for this. We have a very rough draft of a worksheet for estimating cost of an alternative. Of course, an applicant, if they have an alternative cost analysis method they want to use, then they're welcome to go about it however they want. We would always review them, of course. And when looking at this economic, we consider the base cost to be the absolute minimum to achieve water quality standards, which that would be using up all a similar capacity, but just to the point, to the minimum water quality criteria, but not impairing the water. And so then, in general, we would presume that if the cost increase is less than 20%, less than 120% of the base cost total, then we generally presume that's economically efficient and that those alternatives should be pursued if they are resulting in less degradation. This is a non-binding guideline. The applicant is welcome to try and justify it if they think they have certain circumstances where it would not make sense to do that. But that's kind of our general guideline there of what we would expect to happen. Section 9 gets into the non-point sources. The main upshot here is that the non-point sources do not require an anti-degradation review. And then the last 5 sections here, these are mostly administrative stuff that saying, as I mentioned before, that the anti-degradation review goes through all of the same review processes as the NPDES permit. A lot of this stuff is detailed in Rule 8. That so it's the public review, the intergovernmental review, and then it has the same final action and appeals process. And then the last section will have the effective date of the document. And that's it for our presentation here. So if you got any questions over anything in the whole presentation. All right, so let's look at one from Teresa Turkey.
Yes, hi, I have several questions. Thank you so much for that presentation. The first one goes all the way back to why the why these implementation plans that we're discussing right now are non-binding. So I think that was maybe your second slide.
Okay.
Yes, why are they non-binding? Because it seems to me if they're non-binding, then they don't have legal standing, but I'm not a lawyer.
You know, I'm not a lawyer either. I think the intent here is, this is not going to, it's not part of one of our official pollution and ecology commission rules here. Does anybody else?
Yeah, Zach, that's basically true. It's not a rule. I am also not an attorney.
Russell
Perhaps
might.
we have others on the call we may defer to, but that's the general difference is the rules, and they've been through commission rulemaking procedures. And these are guidance documents, which are very important, but we cannot predict the individual unique situations that may pop up that we have to sort through the details. So it's hard to have a guidance document address every possible scenario. But others may have a comment on that. I should step back.
This Russell, I can speak to that at least from EPA's point of view. We don't require the implementation to be a binding regulation, but so long as there is a link to this from your policy, because EPA does have authority to review and approve implementation just like the policy. So even if it's not a binding rule, we still have reach to it. But
Okay.
we have always advised the states, particularly in Region 6, to include their implementation in their CPP under 130.5B6, because you have great autonomy in revising your CPP. And if you should find, say, an implementation procedure that's not working well or just not well designed, you can always edit that in your CPP, and that's the only part of the CPP that you would have to submit for review and approval. And that's not a big issue. That we do that all the time.
So
Go ahead.
I was just going to say, so as a follow-up, 2 questions. Do most states have binding implementation procedures? And secondly, is the CPP a legally binding document?
The CPP is a legally binding document because it's required by regulation, but those 9 elements are also outlining the process for these things. So they don't sometimes they're not very detailed, but it's to your advantage to have, the state's advantage to have detailed implementation so everyone knows what you're doing. And that's one of the reasons we revised the regulation in 2015 and specifically spoke to this in anti-degradation implementation in that revision to make sure, excuse me, that not only the public was well informed and involved, but that it was a transparent process.
Okay, thank you. Sorry, I have some more questions.
Okay.
So we didn't cover definitions, but and maybe this is the wrong time to discuss definitions, but I'd certainly have a couple of suggestions in them. So I can hold off or ask those questions now, whatever your preference is.
Well, we found that it's really easy to get bogged down discussing definitions. I think we're going to try and get through the other sections, focus more on them today.
Well, can we come back to definitions before the end of our call this morning?
Certainly, if we have time for it, I think we can.
Okay, then I'll proceed on with a few more questions then. Why are non-point source sources not part of a review, of an anti-degradation review.
Yeah, the non-point sources are fairly complicated situations. These are often have oversight from a lot of different regulatory agencies. Can be very difficult to determine the exact amount of pollutants coming out of them, I think, in many cases.
I agree, they're really complicated, but much of the degradation that we're seeing in streams, especially outstanding river or extraordinary resource waters, are coming from non-point sources. And I just think this is a bad idea to not include those in this policy and implementation document.
I would just comment that you're right. There are a lot of types of sources, and significant quantities can come from non-point. It's just similar to what Zach had said. Many are regulated in other ways and not regulated by NPDES. And so that's what's made it difficult. But we've chosen for now that this is the discussion and the reach that we're taking right now. Included non-point in a way that the state is required to assure is discussed in the document, some discussion that there's some assurance to be made that other programs manage non-point sources, but we would not require an anti-deg review at this time.
Russell, let me just point out one thing, that the standards regulation actually requires that the state assure that the high statutory and regulatory requirements for non-point sources be considered in anti-degradation reviews.
Well, I would think it would be helpful to cite those other areas where non-point source is being regulated, or if it's being tracked, or there's some oversights, instead of just leaving this saying this is completely out of the realm of this review. So a citation would be very helpful.
I would, we'll note your comment and consider it as we go forward.
Okay, I think for now, that's all the questions I have. Thank you.
Sean had a note, just a note that Teresa's comment about the non-point source, these are included in the BWQ. Carol, you're next up.
Good morning.
Morning.
A question about early on in your presentation, Dr. Carroll, you mentioned that some of the waters that were going to be discharged into might not have a water quality on them. Do we have a percentage of those in the state of Arkansas that do not have a water quality, any water quality data?
I don't know that we have a percentage, but I mean, if you start looking at little creeks and stuff, you know, we generally only have the larger bodies of water.
So half of them, you think, or less than that? Just trying to determine. I mean, it looks like when you know, when we mentioned that the water quality data may become the problem of whoever's applying for the process, then that's going to have an economic impact on those that are wanting to apply. I don't see it on this slide you have up there, but there was one that said that one of them, the applicant was going to be the person who might need to provide the water quality data, and that may be very difficult to do.
Yeah, so it's what we really anticipate on this is that when you're going to be able to get this non-significant degradation, that's typically going to be the larger rivers. And for the larger rivers and streams, we typically do have water quality data on those. If it's a smaller stream where we typically would not have the water quality data, then in most cases, we would expect that it would be significant degradation regardless. So you probably would go with this kind of second option here, where you just kind of go in knowing that there is going to be significant degradation. And so you don't have to do the water quality analysis and just go straight into this alternative analysis and socioeconomic impact review, just assuming that there will be significant degradation.
Okay, so one other question, and I appreciate your answer there, but the socio benefits from the water degradation, what length will they be considered? I know that on the economic, you mentioned 20 years in there, and the socio benefits, how long are we looking? Is that long term? Is that short term?
I don't believe that we have any time period specified on that.
Yeah, I know the economic benefits, there's a 20-year timetable on it, but in the social benefits, I mean, is it something that's going to provide some employment for 6 months, a year? I was just kind of wondering if we needed to attach some time frame to that.
If you knew the time frame on it, that would be something good to include. I don't think there is any limit on how long or short that time frame could be, at least in the current
right. And my problem with that is if you do a degradation and it only results in a 6-month social impact rather than a long-term social impact, to me, it would make the degradation be less worthy. And I don't know if that's taken into consideration or not.
Yeah, if we knew the length of it, I think we would take it into consideration.
I think it's valid comments that we'll make note of, certainly.
Okay, thank you very much.
We had a comment in the chat. What are the specific requirements for determining BWQ, the number of data points, period of record, etc.? And then going on to Russell. Russell, we're keep on going back at each other. I think I hit mute on you on accident. I'm sorry.
Can you hear me now?
Yeah, I hit mute on you on accident.
I'm sure I said something really witty to begin with, but I'll try again. I just wanted to ask Zach, I mean, are y'all using EPA's economic guidance to determine that the level of socioeconomic impact? And I also wanted to speak to one of the other questions earlier. I think, I'm not an assessment expert, but I believe based on the state's, probably your 2016 integrated report or 305B report, I think about half of the state's waters are assessed, half or not.
I appreciate the comment, Russell.
So what about are y'all using EPA's economic guidance or not?
Oh, I believe we do. I don't recall specifically. We've got guidance manuals and worksheets included. I don't know how much of that we published with this.
Okay.
Carrie or Zach may recall.
Well, just want to make sure, I mean, because a lot of states, actually New Mexico is using it we're assisting them with doing that for a variance project for small dischargers. So, I mean, even though it's somewhat dated, it's a pretty good guidance to follow to determine socioeconomic impact. That's it. Thanks.
Okay. Thank you.
Jesse Green, you're next on my list for got your hand raised.
Did we ever address the number of points for the baseline water quality?
I don't, but just some thought on that because it came up earlier when I commented on the 10% increment and consumption of multiple 10% increments and so forth. I want to point out, and somehow we could explain this better, but we have the ability to set protective limits in any regard, whether we have our CPP addresses methods for setting protective limits in cases where you have a lot of background data or none. And those limits are set on worst case scenarios, minimum low flow, as Zach mentioned, or critical flow as it's defined depending on the pollutant. So, you know, while we do have the ability to track these increments of consumption at a particular location on the map, we have the ability to track the 10% usage and so forth. We also have in place these methods of setting protective limits that ensure you'll never dip below the water quality criteria, from an NPDES permitting perspective at least, maybe not considering some other effects, but at least if you had multiple sources nearby, they're modeled together, they're evaluated together, and those methods set up by the CPP ensure that you do not ever, at least in theory, mathematically, you will never cause an impairment at these locations, at any one particular location. So, you know, these discussions and ideas of tracking these increment consumptions or 10% usages, they become less important when you start to look at the way we issue permits at worst case scenario. I don't know if that comment helps. It might even confuse more, but that's sort of the realization we came to as we dug through how do we track and what is the importance and so forth. Even in cases where some facility may not try to establish background water quality and just assume degradation. They know the stream is not impaired today, and after their new permit goes into place, they can rest assured they've got a protective permit that won't cause an impairment, you know, later, because we'd set protective limits by that permit. At worst case scenario, you know, most days streams flow more than the worst case scenario, which they were evaluated at. So I guess not to go off on a long discussion on that, but I just wanted to mention that when you start thinking on that terms, it makes the tracking a little less important in the long run.
So Brian, on that, we had a follow-up. I don't know where we're getting feedback. To follow up the occurrences when no water quality data exists, it is assumed to be significant. However, how can we assure the existing uses are being protected since an unknown amount of assimilated capacity is being used?
Right, that's what I was going into this discussion there that I kind of got off on a rant, but I was just simply trying to point out that as new permits come in, if they're nearby and potentially have a cumulative effect with another permit, they're evaluated together at the minimum or at the critical flow. And that assures that those locations there and downstream cannot exceed water quality criteria.
To go on to the next comment, I'm going to read it. It's more the last part of the comment that I think needs to be addressed. I didn't hear the response to that. And smaller streams are assumed to be most likely suffer from severe degradation in absence of water quality data, and the applicant proceeds forward with the alternatives and the economic analysis. How do you determine what percentage of the assimilated capacity has been used by the permittee without water quality data? I think we were just discussing that, but the last part is who collects the needed data?
Well, if there's needed data, the permittee will need to collect it. But like I was saying, through this process, they may choose to assume degradation and accept limits the way we're directed out of the CPP to assume, you know, worst case scenario, but also deciding how much degradation they may be allowed to consume, that's a matter of alternative analysis to get into the decision-making process related to what technology is proposed as baseline and what technology is out there which may be economically viable and yet also provide an improved effluent limit, a lower degradation through improved technology at an economically sound ability for the applicant.
So how are limits set with no backwater BWQ?
Well, the baseline is determined the same way we set them today. If it's a low background flow or low flowing, zero background flow, and they get the fairly low limits and based on worst case scenario. But also when we apply the alternatives analysis, we may end up with an improved technology at a practicable cost, which results in a lower, more restrictive effluent limits.
All right, now we're back to you, Jesse. I mute you again. I'll try to make sure you got the unmute request. Sorry.
Wait, okay, now I'm unmuted. I have a question just, well, I guess the first one really, about how the assimilative capacity will be calculated for the parameters that DEQ has not adopted numeric criteria for. So like say phosphorus, will you be using any specific numeric criteria in lieu of the state having their own, like EPA's recommended numeric nutrient criteria?
No, we've not promulgated the numeric criteria for example, nutrients. And unless there's an impairment, we would not have a need to do that.
So there won't be, so it won't be required that they have to undergo, produce an analysis of alternatives or an economic or social development analyses for any nutrient related parameters. Is that?
Not if there's not ordinarily a limit needed, like in a case where there's an impairment. But if there's no numeric criteria promulgated, no impairment through the narrative criteria, then no, and no technology limit in place, then no.
Okay. That's my only question for now.
We're going to go to Justin, and then we'll come back to some of the comments that are in the chat.
You guys hear me okay?
Yes, sir.
I think Jesse stole kind of part of my question there about the narrative criteria stuff. So let's say the designated use of fisheries is impaired and it could possibly be degraded by the issuance of a permit. Where does that review occur at DEQ? I mean, obviously it's a professional judgment type of thing, but are the engineers consulting with like the fisheries planning folks and that sort of thing, or does that even occur? And, we could help possibly too, if that's a sort of a build some sort of criteria or I guess framework for that. And the second question I have is like, I guess it's kind of also been asked and answered a little bit, but what about existing permits that are already using a assimilative capacity, and how will they factor into new permits? Like, will that be reviewed?
Okay, no, thanks for that. I mean, again, good questions about I guess we're still looking at nutrients, we'll just say it. But if there is an impairment, then yes, we'd have to evaluate, and that'd be a scientific-based evaluation on determining what's the appropriate numeric translator, I guess you might call it. It may not be, it would essentially for the...
Whatever it's supposed to be for that Ozark Highland stream or something like that, for a fisheries example.
Right. Yeah, it's basically what I was saying is we'd have to work with our scientists in office and through whichever office. I appreciate the offer you'd mentioned. We'd all basically have to work together to establish some sort of scientifically based translator to evaluate if and what a permit could discharge into an impaired location. I think I touched on most of that, but yeah, essentially, if there is an impairment, we'd have to consider an appropriate limit. You always have to make sure that you don't issue a permit which may cause or contribute to an impairment if one exists. And the second question, I remember. Oh, I think you were asking, how do you ensure when there are multiple permits already in place, or if there are permits already in place? And generally speaking, similar to what I had said before, if there's multiple permits, they have to be evaluated together. If there is a chance, they may impact the same water.
The cumulative effect will be looked at then for existing permits and like new ones. Like the cumulative effect will be assessed during the new permit, like taking into account the existing permits may have already used up some assimilative capacity, or right?
If they have potential to accumulate on each other, yes, they should be evaluated together.
Okay.
And that's what we'd have to determine really through various types of modeling that's available to the permit writers and other engineers and scientists in our office. There are several routes in which that could be evaluated.
So going on this conversation, only after an impairment of nutrients will be addressed, and does it fit with the anti-deg? There's a question that was brought up in the chat.
You kind of broke up the first part of what you said, Colby. I didn't.
Only after an impairment, nutrients will be addressed, and does this fit with anti-deg?
Yeah, I mean, yes, it fits in the sense that if there is a criteria to establish a limit, or if there's an impairment, a determination would have to be made on an appropriate limit, which would be a baseline limit or a baseline to evaluate the alternatives analysis.
Moving on, we're going to go to Teresa Turk.
Hi, thank you. I've got a couple more questions. This is how BWQ is established. This document doesn't provide any detail into what is adequate to determine BWQ. When samples must be collected, how many is an average taken, because BWQ right now is defined as a fixed concentration, but concentrations vary throughout the year. If BWQ is established in the rainy season, concentration may be lower for some parameters at these higher base flows. So if you could provide a lot more information on how you define BWQ, that would be very helpful. Because there are seasonal fluctuations and concentrations will be varied, and you've got it as a fixed concentration. So that implies to me that it's a one-time number that you hone in on, and understanding how that is done would be incredibly important.
Yeah, I can understand and appreciate the comment. I do acknowledge that there could be some seasonal discussion in there. that may or should be made. We'll consider that rather than getting into a lot of ifs right now, but I appreciate the comment and we'll make note of it.
Well, I would say that this is probably one of the most important factors, identifying exactly how you come with a BWQ. I mean, and having that extremely well defined and an example in the document so that it's not ambiguous at all. Understanding that methodology and how you went about it, I think is incredibly important. So I'd appreciate your thoughtful review on that. So the next question I have or comment is when you're going through the tier 2 assimilative capacity that you just did, I mean, that's very much a very simplistic situation, but you're not really accounting for the error or the uncertainty. And as everybody knows, there is huge variability within the data collection and sampling of water bodies. So how do you deal with that? I mean, shouldn't we be much more conservative and also have a great deal of information and doing those kinds of calculations of assimilative capacity?
I guess back to the point I had mentioned earlier is we still have the ability to set protective limits that are based on critical flow and worst case scenarios that may go along with those, and really determining baseline water quality can become less of an issue, especially if we're not trying to determine and establish a 10% threshold in an applicant, which may assume degradation and move forward with setting a limit based on worst case scenarios and using that as baseline technology to begin an alternatives analysis. And the alternatives analysis should result in a better technology with lower limits. I guess my thinking there is you take in that process, you take some of the variables out of it when we're setting limits and starting from worst case scenario and moving from there into alternatives. I don't know if that totally addressed your question, but
well,
it was an attempt anyway.
I appreciate the attempt, but you know, I am concerned because this document is so general, and it doesn't seem to be that protective. We have really different kinds of geology throughout the state. So some areas need much more protection than other areas and much more of an uncertainty principle. And I'm hoping that, or I was hoping that this document would kind of entail a precautionary approach, because we do have a lot of problems with water quality in our state. So the other thing that really concerns me too is the lack of reference back to either parts of Regulation 2 or parts of the CPP. So it's very difficult to follow where some of the comments that you're making, where they actually are located within that very large document. So I would just really lobby, encourage, advocate that the more references and links that you could put in the document, the better, because otherwise it's very difficult for someone to follow, even somebody that's gone through the CPP quite a bit. So thank you. I'd appreciate that.
Hey, this is Carrie McWilliams with DEQ, and just kind of as a follow-up to Brian's comment, and this has been, you know, this is an evolving thing, and this is kind of my interpretation of what Brian's response was, and his point was, rather than get into the weeds, and I don't use that term lightly, but rather get into the trouble and the expense of an evaluation based on background concentrations and that sort of thing, when what actually drives the bus is just saying, okay, we assume the degradation's there, and that that evaluation is kind of looking at it in reverse to provide that starting point of, we have a baseline technology, we are proposing an additional technology that would reduce it X amount in the available capacity, total assimilative capacity, and that is that portion that we're saying that we or whoever the applicant is taking. So like I say, it's coming from behind rather than ahead, because we anticipated a lot of these. Again, the search and quest for the data, the background data would be such an onus on folks when it just, get ahead of it and just pursue it from the perspective of it exists. Anyway, just wanted to add that additional comment.
Okay, thank you. But that's allowing us to trust you all without, it just seems there's insufficient documentation on how you're coming at this so that somebody from the outside can understand your methodology. So if that could be clarified or enlightened or expanded upon, I would really appreciate it. Thank you.
This is from the chat. How do we handle streams listed as category 3 for nutrients, insufficient data? Would the department be conservative in protecting water quality? And then page 11 shows that the existing permits are included in BWQ. Would recommend the contribution of the permitted source separate from BWQ. Colleen? All right, go ahead, Brian.
Yeah, just simple answers. Yes, we take a conservative approach and use best available information. Certainly if a stream is impaired, we have to set limits based on that designation. Otherwise, we use best available background information to make our decision.
Colleen?
Thank you. I'm going to jump back to some comments earlier about the issue of parameters for which there is not a numeric water quality criteria, and in particular nutrients. And of course, when we're concerned about protection of drinking water sources, nutrients are a major consideration. And so what I understood from what Brian and others said was that for those situations where there's not a numeric criteria or criterion, that there are sufficient, or DEQ's position is that there are sufficient permitting safeguards in place to, and he said, in theory, protect discharges from causing impairment. And multiple times it was stated that if there's impairment, there would have to be an appropriate limit. But we're not focusing here on high quality waters, on impairment listings. We don't want it to get to that point. We're talking about anti-degradation. So what will be the process to ensure that there's not, for example, nutrient degradation of high quality waters?
Well, just on surface, the way the anti-deg structure is set up in the guidance document is based on a numeric criteria. So if it's not in place, perhaps there's other ways for evaluation. It's something we can talk about. But I don't know, the way the current structure of the anti-deg is set up, it's numeric. It's based on a mathematical evaluation to set limits and then going backwards from there to determine better technology. So if there's not a number to perform mathematically, it becomes, in my mind, there's some question of what you would do with a narrative criteria, which may be all you have right now for nutrients. I don't know. I'm open to ideas. What do you got?
Are you asking me?
Sure. Yeah, it's
Well, I will get back to you on that, but I do think that, it's a very important issue, and it's a very significant hole in this whole policy if we don't have something in place to address those situations. So yes, I think it deserves much further consideration and discussion. So I appreciate that.
okay. Thanks.
Thank you, Colleen. Jesse.
I will just say again that I do recommend that using EPA's recommended criteria for nutrients, they have recommendations based on level 3 ecoregions, that would be a good starting place and something to use in the interim of Arkansas promulgating numeric nutrient criteria. And then I did have another question about, I know at least for a while, it was originally considered factoring in a margin of safety whenever calculating the assimilative capacity. Could you talk about, I guess, really just the thought process of why that's not being included?
Well, I think it is included. If one was to, it depends on how they move forward and establish their level of degradation, and or if they assume degradation and move forward with a limit which establishes the baseline technology. In either fashion, they set those based on minimum flow and setting limits in methods established by the CPP. They're protective in that they're set at worst case scenarios. For example, minimum flow, and most days of the year, it depends on the stream, but many streams don't flow at minimum flow much of the year. So in a sense, there's protection. And then from there, the limits determine set the baseline technology, which you then evaluate for improved technology, for lower limit, more protective limits as better technology is selected. So there are levels of protection built into that process as you move forward, through the progression of the process.
Okay. Thank you.
Russell?
Just to kind of go back to where criteria don't exist in the state standards, whether it's nutrients or whatever. I mean, when you're doing an anti-degradation analysis, one of the things you're doing is you're looking at that baseline, what your water quality is at the time of your action. So if you knew what the concentration of that parameter you don't have criteria for, whether there's no EPA criteria or you just haven't adopted it yet, that can still establish a point of reference to determine how much degradation you would allow for that particular parameter. I mean, is that something you've considered?
Perhaps. Haven't thought that far into it.
Just a thought, you know, I mean, that's at least one way to do it where you don't have criteria.
That's all the comments that we have in chat as of right now. Any other comments?
Earlier, I had mentioned, we kind of perhaps going out of order, but it really doesn't matter. I'd mentioned if anybody had prepared any comments or discussion on the CPP where we left off in the last meeting, those are certainly welcome. And since we're kind of at a pause in the anti-deg discussion, I would welcome those, or send a call out for anyone that may have prepared anything on that. So any CPP questions or thoughts?
We got one that came through chat. Would also like to see a time frame for review of this document. The CPP was updated 6 times in the first 16 years and should have been updated well before now, 20 years later. Most of these things are tied to Rule 2, reviewed at least every 3 years, and the assessment methodology reviewed every 2 years.
Sure, I would acknowledge that comment, and I think we touched on that a little bit last time, that some folks were looking for some more certainty on how often the CPP would be, not the word wouldn't be renewed, but at least examined for updates. And I think it's a good question. I don't know what we may resolve for the document, but it certainly, I would at least myself agree, it needs to be updated more often than 20 years. Do we have any other, Colby, anything else coming in, or
Nothing as of right now.
Russell's got a hand?
Oh.
Yep.
Should be unmuted, Russell.
Hey, just a quick question on what are your deadline for comments on both the CPP and the AIM, whether together or separate?
Sure.
'Cause I've got just to let you know, I mean, I've got our permits and TMDL and 303D folks are all looking at the CPP, and we're going to combine comments, and I just want to get an idea of what to tell them and when their cutoff is.
Sure. Thanks for that question, because it's always good to update and remind everybody. We are accepting stakeholder comments right now, and then this discussion is part of those. So we're making notes and accepting them now. But we anticipate by the end of the next meeting, July 21st, we'll announce, at least announce or have a plan put forward for when the 30-day comment, if it's 30 days, I don't even know if we're committed to that. But I believe we're going to have a 30-day public comment period. And during that period, anyone could provide comments, including the stakeholders or those listening, or others interested parties may provide comments. But we can give you a little more insight to when the 30-day comment period will be. We're discussing that right now. We hope to have that information at the next meeting.
That's great. I appreciate it.
It'll be after, I mean, we hope to start the 30-day comment period shortly after the final meeting. Which would be
Well,
after,
it's like herding cats, so any help you can give us will be good.
yeah, that's the idea for now.
So there was a question. I just told them in chat we'll discuss this at a later time. They asked about the meeting for July 21st, when it would be, and if we could clarify the time. And on
We
that.
don't have the time yet, but similar to this meeting, we're looking at I think some other activities that day. I don't know if there's any possible conflicts with, I don't remember if the EPA webinar is still, or the WOTUS webinar is still going on at that point, but we're considering the best options for timing. We don't have a time set at this time, but we're hoping to keep it July 21st.
I was talking and I was muted. Sorry about that. Teresa.
Thank you. I've got one comment about the CPP. On page 78, the dissolved oxygen parameter. All these other parameters that you have in here, like pH and some of the minerals, reference back to Reg 2 because those are numeric criteria. And I don't see that here with dissolved oxygen. It just talks about using this model, this Streeter-Phelps model. So it would be helpful to add a lot more specificity to this parameter and referencing back as you have done in others that are in this section.
Sure. I remember the pages you're talking about. We can provide some more explanation of how that's developed. Shane, you may have some comment too, or if you remember that location, you probably do.
Shane, you're unmuted.
Yeah, we can certainly add the section in the Rule 2 where the DO water quality standards are located.
That would be helpful, and it would make the document a bit more consistent. And even within the assessment methodology discussion about dissolved oxygen and getting continuous data, there's still some ambiguity about how that calculation is made on a daily basis. So I just want to throw that out there, that there's still some ambiguity about that, and any more guidance or examples that you could provide would be extremely helpful. Thank you.
Thanks, appreciate it.
On page 12 of the AIM has a heading for consumption of dissolved oxygen SAG. Is there more information on this topic?
I mean, not that we've put out or published, and not other than what you see in the AIM. What specifically is the question, and we can look into it, or if they want to provide more, I guess, more specificity to the question.
That's all the question has for now, or more. Does DEQ have a shapefile or other public available map denoting what is considered WOTUS?
No, we do not.
Colleen.
Thank you. Back on the sort of procedure that you intend to, at the July or by the July 21st meeting, announce the 30-day public comment period on the assessment methodology or the anti-degradation assessment methodology and the CPP. That seems to imply to, I'm just wondering, have you factored in any time to review to revise those two documents based on stakeholder comments? That's my first question. Then I have a second question.
Yeah, we talked about that not long ago, about revision time and when we might make a revision. And it's a good question. I think we'd have to talk more internally, at least with my management. But there is still some uncertainty if we'd make any revisions or go to public notice first, because it might be more consistent to hear everyone's thought with one document rather than hear the stakeholder thoughts, make changes, and then put it out publicly and get different thoughts. I guess what I'm telling you is that's not fully determined, but we may be leaning to slightly more towards rolling forward with the 30-day comment period and then considering updates afterwards.
Yeah, I guess there are two, two approaches, and my gut feeling is though that it makes some sense to, if you agree with some of the stakeholder comments and you think that revisions would be beneficial, it'd be better to get those changes made before it goes out to a wider public comment process. So I think I would encourage that you give, you give the stakeholders, like if sometime after the July 21st meeting, we have some time to get in some written public comments, even if it's a short time, because I know you want to get this done, but, and then you can take those into account and make revisions to have a better final documents. I think that'd be preferable. But in any event, I'm going to make a strong plug for having longer than a 30-day comment period. No surprise, but these are significant and complex documents. We've been waiting on them for years. DEQ's been working on them, and so we're just, we've seen some versions along the way, incomplete versions, and ones that now have changed significantly. So I think that a 30-day comment period is not sufficient to allow for public review.
Okay, on both issues, I can understand your perspective, so I appreciate that.
Thank you.
We'll talk more about it among ourselves.
Hey, Brian, we have a follow-up from the question earlier about the consumption of dissolved oxygen SAG. Guess I was wondering what this looks like during the permitting process, or how often will the data be available for this to be calculated? More information on the source for this section would be helpful.
Okay. So some additional clarification and specificity on the use of the section we can certainly consider.
That's all the comments I have as of right now in the chat. Is there any other comments out there or questions?
Kobe, it looks like.
Yeah, I was getting to where'd she go? She put her hand down when I went to unmute. Teresa, did you have a comment?
Can you hear me now?
Yes. You moved lowered your hand and it moved your name when I went to unmute.
It's a little confusing if you only unmute me or if I have to also unmute myself. So anyway, forgive the delay. So I did not know if we could talk about definitions or if we have other things to discuss. I didn't seem like there was a lag in the conversation.
Yeah, sure. We have time, and go ahead.
Okay, so this is just a very basic question. In the definition of a water body, it doesn't really say if that's by HUC code or reference back to Regulation 2. I just would like a very clear definition of what is considered a water body.
Okay. We can take a look at that. I don't know if Carrie or Zach or any of you guys might have a comment, but I really don't. have much response to that other than we can take a look at it.
Yeah, there needs to be like a scaling in there. If it's by HUC code, or if it's the Appendix A in Reg 2, or you know, there just needs to be something that references back to a map, or because otherwise it's just very general. So you don't even really know what you're assessing, really. So if you all could tighten that up, that would be very, very helpful. My second one is temporary lowering of water quality. So what is considered temporary? So is that 2 weeks, 2 months, 2 years? Again, I'm really kind of advocating much more well-defined language than what is in here, because you know, temporary could be, you know, 10 years or 15 years. There's no there are no bookends on that.
Okay, are you referring to stay short-term activity authorizations?
I'm referring to temporary lowering of water quality. Lowering of water quality that is non-permanent effects. So the length of time during which water quality will be lowered. Well, what's the short duration? What's the length of time? It would be helpful for the state to provide guidance on that, some kind of time frame.
But you're reading that language from the anti-deg implementation methodology?
I'm reading that language from the definitions in the anti-deg implementation methods.
I'd have to take a look at that. I'm not sure. Others might be able to comment on that. I at first assumed that's referring to short-term activity authorizations, which generally the authorization itself spells out what the project is and how long it takes. But that may not be. I may be on the wrong track. If anyone can guide me on that one, please let us know.
Can you hear me?
Yeah, is that Russell?
Yeah, that's Russell. Hey, Teresa, the EPA has always said that Tier 3 anti-degradation can be for weeks, but not to exceed months. And the point is that you don't change the conditions that led to that Tier 3 designation. So it's allowed for things like, you know, repairing a bridge, you know, a pipe that goes across in a state park. Weeks and months is what we've said.
Okay, if that language or some reference to that could be put in there, I would really appreciate it. Because I just, when I read it, I thought it was very open-ended. But if it's weeks and not months, that would be that, or an example like you just gave, that would be incredibly helpful.
I think that language is in our Water Quality Standards Handbook. The most recent edition speaks to that.
Okay. Well, for somebody that is trying to follow all this, we've got a lot of documents. So cross-referencing is extremely helpful. So another one, activities. So I haven't had a chance to go back and look up the Clean Water Act, Section 401. But does nutrient trading, is that covered in activities? I realize right now we don't have a nutrient trading regulation, but we may in the future. And any additional nutrients that would be placed in a stream, I think would be something that really would be need to be considered under anti-deg, and even more so now that I guess the tone of the discussion today was that since there's no numeric criteria, we're kind of left not reviewing that or assessing that, and I find that really troubling, especially since nutrient trading has been discussed and will probably be back on the agenda here pretty soon. So it would be helpful to say whether it's included in these activities or not.
Okay, we can take a look at that and get a more firm I guess, some more firm thoughts on that.
That would be very helpful.
Question, are the total pollutant loads being considered as a criteria for degradation as opposed to the pollutant concentrations?
I'm gonna touch on that question with an answer. I'm not sure if I'll answer the question. Generally speaking, to apply the way we have framed it and the way we envision it, that applying anti-degradation implementation is that new loads are what trigger evaluation. For example, one of the many ways a person might, I guess, I don't want to say sidestep, or I don't want to say sidestep or get out is not the right word, but if a permittee were to expand an activity, a portion of their plant, and produce more material in some way, and that possibly expands a load on a receiving stream, they may put in better technology to basically cut their load back in half to net out to no additional load, and that may cause for no additional review under anti-degradation. I don't know if I said that well enough, but the trigger for review is additional load, not necessarily concentration. Now, albeit, remember, concentration is a huge factor in everything we do in setting limits, writing new permits, etc. We always protect water quality, and concentration is a very important part of limits. But determining if something is new, in quotes, a new facility or a new expansion, it's determined on load to the stream, pounds, pounds per day or pounds for some period. I don't know if I've fully answered their question or what.
That's all we got for now.
Yep.
Justin.
So I'm going to take a play from Teresa's playbook here and ask about definitions as well, just because I think it's important. What is baseline? When we talk about establishing baseline water quality data, are we talking about baseline from when this document is accepted and promulgated? Are we talking about when the criteria were established from ecoregion data back in like '87? So I think it's important to spell out in these documents when like what is the time period of baseline? Like when does it happen? So that's just a comment. And if you have an answer for me, that'd be even better.
I'm a little concerned about tripping myself up with an answer. I don't know. Zach's looked at it a lot more in recent days. May have some answer, but it's okay if you don't.
Yeah, I mean, as it is written right now, it says that the baseline water quality will include the pollutants that are already permitted to be discharged from a facility that's expanding. I mean, it's as far as when we determine this baseline water quality, it's currently written in there that whenever the first time somebody looks at a stream for a proposed new or expanded discharge, that's when we would go out to establish the baseline water quality for that stream.
Okay, well, that answers the question then. So as soon as you apply for the permit, that's when the baseline water quality data is established.
Yep.
Okay.
Colleen.
I think there's some of us that disagree with that approach, possibly. I'm trying to remember back from some of the earlier stakeholder meetings. My recollection is that at that time, DEQ was contemplating a process to go back and evaluate the contribution of existing permittees. That would be counted against the assimilative capacity. Am I correct in recalling it that way?
Perhaps, but I think that may still be in line in some way with what we have today.
Hey, this is Carrie. One of the things I just wanted to point out, because I know in the focus group this got to be an issue, is, and I don't know if this will make you revisit the question, but on baseline water quality, it kind of, it trips people up in the sense of if you have a higher baseline quality, or baseline water quality, it actually makes that total assimilative capacity smaller. And so it's actually more, the higher baseline water quality is, the more stringent it'll be. If you look at, at the time of the dinosaurs and the water was great, you're actually increasing that assimilative capacity. And like I say, it's just kind of a little mind game you got to kind of remind yourself of what it is.
Colleen.
I'm sorry, Carrie. I think that was a good explanation, but you cut out, at least on my end, I couldn't hear about half of what you said. So I understand the gist of it, but again, I think this is an issue that needs some further discussion and explanation. And maybe I'll just give you a call.
I'm looking at the last, well, it's not the last sentence, next to last, and it says, for an expanding discharge, the baseline water quality shall include the levels of pollutants already permitted to be discharged at maximum flow. I think the intent is to capture today's water at that proposed expansion location, in its current state. That would be the baseline. So any room for additional pollutant load would have to consider that those pollutants are already there. I don't know if that helped. I think that kind of went along with what Carrie was saying, I believe, but she did cut out on my end too. But just to acknowledge the comment, I would agree we can continue to look at it. If there are improved explanations to be made, we can evaluate it.
If a permit is already present, would the BWQ already be calculated?
Would it already be calculated? I don't know exactly what they're getting at, but it would, the BWQ should include, kind of along the lines of what I was saying before, it should include the levels of pollutants already there, or permitted at least, potentially there through permits.
So the BWQ changes is reevaluated each time a new permit application is undertaken, correct?
Potentially. That goes back to what we were saying before. permits may be there and their limits got put in effect because critical flows were evaluated under the methods of the CPP, and so the limits are in place. So any multiple permit scenario would model or evaluate water quality effects based on cumulative effects of multiple permits. The BWQ may not necessarily be evaluated if each of those assume degradation each time. That there may or may not be a BWQ evaluation. If that's how the review went, it may have gone straight to assumed degradation and then evaluation of socioeconomics and alternatives analysis. So I guess to answer the question, not necessarily. There may not be a record, potentially not a record of BWQ for the last application. I guess we'd have to sort of tease through the scenario of how the review process went and what the file records show.
So Carrie messaged me and just to get the gist of what she said out there and the last time when she was cutting out. For a higher baseline, the TAC is lowered. This effectively is more conservative when evaluating a tier 2 water through the anti-deg process. That's all the comments I have in chat. Any other comments or questions? Sean is typing up one more, and Colleen, going to you.
Part of my question, and thank you. Part of my question was, again, for existing discharges that are not proposing to expand, whether DEQ was going to go back and the next time the permit was renewed, do an anti-degradation review. So one was never done. Will one be done for those existing discharges that are not expanding upon their first renewal once the anti-degradation implementation methodology is in place?
Short answer is a renewal only with no additional load does not trigger additional review under this aim. Probably a lot longer answer out there that I could expand on. Let's just leave it at that for now. And what was,
sure.
Was there more questions?
I get that's the answer, but this is what I was thinking, that there was some consideration during previous discussions about doing that, about setting up a process even for renewed permits without increased loading to go through the anti-degradation review.
That's just not the way it's set up. If they're not proposing expanded load, we aren't applying a trigger at this time. Just renewal only is not intended to.
Yeah, and I understand that that's, I guess, now the position, but the idea was that since they never had a review, even though it was required by law, that the first time they're renewed after this policy is in place, that they go through that process. Anyway.
Yeah, I see what you're getting at. I mean, I wouldn't say they didn't get considered under the Reg 2 policy was in place. So if they were permitted, I have to assume they were evaluated. Now, we could get into probably a long discussion about what that means to everyone, but they are permitted a certain way. So I don't see what would trigger. That's sort of where we've ended up, is that additional load would trigger it, not a renewal only. So if they are permitted, they'll continue to hold a permit. And I will say, getting the original permit and continued renewals every 5 years, they should have and were continued to be evaluated by the CPP under those methods I've been mentioning, to set limits and check limits and so forth. all those protective methods spelled out by the CPP were evaluated and reevaluated, so they should and they better have a protective permit to protect the water quality of a receiving stream. But I guess our position right now is that unless there's a trigger, which would be more load, we're not going back through this AIM procedure.
I understand that. I just think this is a comment that we will continue to make, because while there was a review done on the permitting to determine whether there was potential impairment, I don't believe that there was actually a true anti-degradation review done, even though that language is, the boilerplate language was in all the past permits.
Okay.
Thanks.
Would it be beneficial to use the data requirements in the assessment methodology as a starting point for determining BWQ, but being sure to stay away from the shifting baseline syndrome?
I don't have a strong comment on that. I'd have to talk more with the assessment folks to look at that language and consider the comment. If you've got more discussion on that, please send it in.
Just a note to Colleen's comment, there doesn't appear to be a document of anti-deg review of previously issued permits.
Okay, well, that seems to match our discussion we just had about what was in previous files.
Colleen.
So I'm sorry, that comment, was that from somebody at DQ? And I didn't hear.
No, ma'am. No, ma'am. That was another stakeholder.
Oh, okay.
You want me to repeat the comment so you hear it?
No, that's fine. I thought it was somebody at DQ. So thank you. But while I guess I'm unmuted, I do have, so what is, before I go further, do we have anything else on the agenda today in terms of DQ presentations, or are we just now down to stakeholder comments?
Yeah, we're just in an open forum on either CPP or anti-deg. So if you've got questions or comments, go forward.
I do, but I don't want to monopolize the conversation. So I can save these for written comments, or could you tell us, Brian, what are your thoughts on for the July 21st meeting, just to get an idea of, what we're covering?
Yeah, that's what I touched on in the beginning, just to mention there that we were, in my mind at least, it's going to be largely open forum as needed. I mean, there were stakeholders earlier that had said we may need more time, and just evaluating that and our continued discussions, I don't know that we'll need more time than the 3-hour meeting we've got proposed for next time. But I mean, that's the idea, is to provide as much time as needed in these meetings to talk about any new ideas anyone might have. But we're also open to you guys if you got a format suggestion. What we're considering at this time is just maybe highlight some of the key areas that have been brought up and offer most of the time to the stakeholders for questions or comments. We welcome any ideas.
Well, are there other questions waiting, or should I go ahead and ask another?
We are caught up on questions on chat, so Colleen, go ahead.
So in the definitions, there are several references to waters of the United States. It itself is not defined, but it does say that it's the definition of waters of the state says that for purposes of the anti-degradation implementation methodology, waters of the state include those waters meeting the federal definition of WOTUS. But then within the definition for water quality standards, it refers to WOTUS. The definition of pollution refers to WOTUS. The definition of pollution concerns refers to WOTUS, and so on. And so my fundamental question is DEQ, what's DEQ's intent on permitting going forward? Are you going to, where it says includes the definition of WOTUS, is it includes but is not limited to? Or are you going to strictly be issuing permits based on the federal definition of waters of the United States?
Well, in PDS permits obviously have to be permitted for waters of the U.S., and we have to permit waters of the state through some type of permit. I guess some of those details remain to be seen. Bob might have some comment if he's still on. I hate to jump too far out, providing visionary, path forwards, but
Brian, this Russell, I mean,
yeah,
I can say one thing, in pretty much every state's definition of waters of the state has always been more expansive than the federal definition of waters of the U.S. And with the revision to the waters of the U.S. rule, they're even federal waters or jurisdictional waters are even more limited. And I posted a link where there's some information on, and I think Colby repeated it, but there's also some webinars available, and I think I put a link to that as well. But there's several challenges to the rule right now, and one of there has already been a legal decision, I believe it was in Hawaii, regarding because a discharger could actually avoid limits by moving a discharge to something that is not a water of the U.S., thereby avoiding a federal permit. But so it really falls to the state to protect their waters where we don't have federal jurisdiction.
Yeah, no, those are great comments, Russell, and I appreciate that. Yeah, I'm glad you said it. And I wasn't really wanting to get into all the challenges and so forth and trying to predict the future, but you are right that waters of the state in Arkansas is far more expansive than water of the U.S. And Rule 2 applies to the surface waters of the state. So we would have to permit, and presumably a permit that looks just like they do now, in a lot of ways at least. But what title goes on those permits, if that's NPDES or something else, we'd have to figure that out. I didn't want to go too far predicting the future though, so I was just going to defer to Bob for further, or to Dr. Blands for further comments. I don't know if he's still in the meeting. I know he had to leave earlier, so.
Yeah, Bob had to go to another meeting already.
Okay.
So in regards to WOTUS and the absence of a national database differentiation in the intermittent and versus imperial streams, how will DEQ distinguish these water bodies?
We'll distinguish them through the guidance that's really being discussed in some of the webinars that Russell mentioned. I've attended some of those webinars, and nationally there's a plan, but we will determine what is applicable as the future comes.
Sorry, I was muted. Colleen.
So just a continuation of my previous question, my recommendation would be that the definitions that seem to be limit the application of this to waters of the United States, that be deleted. And, if you need to say anything, it's waters of the state for the reasons that have been previously discussed.
Okay, we'll look into that.
Concern, pollution, water quality standards. There are others. I haven't marked them all, but anytime where those definitions seem to just refer to water's beneficial uses, there are a lot of places where it says, it seems to limit the application to waters of the United States.
So I have one quick question about the July 21st meeting. Will the July 21st meeting cover additional AMI material or be a repeat opportunity to discuss the same topics?
We don't have any additional presentation material. If someone has, particular questions of interest, we may touch on some new topic, but I mean, we presented this today in a way to cover it and invite comments or questions. We don't have a presentation for next time yet or planned. But, if there are additional areas you find as you go through these documents and you find areas which we haven't expanded on or details we need to get into, we can at least field questions for consideration and possibly provide some answers or direction as we see it. But no real new ground to cover next time, unless someone brings it up.
The AMI Part 4C states proposed new and expanding activities may proceed, but with no net increase in parameter load. By definition, if a new expanded activity requires NPDES permitting, then it will involve new or expansion pollutants. Under what scenario could a new or expanded discharge pass Tier 3 review?
Okay, for Tier 3 review, that, Carrie, am I missing something? But if I recall, none. No, it wasn't intended that Tier 3s are to be permitted for additional load.
Yeah, the Tier 3s, they're early on in the process. There's no additional load that's increased. You could, that's not to say you couldn't do other things, but they would just not have any increased load on the stream.
Yeah, they would have to be a form of, I don't know if we use this word, don't remember, non-degrading option, provide some way they could expand and not increase in load.
There was a follow-up, like what things?
Well, for example,
A no discharge situation would be one. Obviously, that's not applicable everywhere in the state, but that's certainly something to consider.
Yeah, I know we talked about that, some sort of non-discharging permit or some type of routing of their effluent to another water body, or
there's probably technologies, I'm not in the business of designing treatment plants, but I would imagine there are ways to further minimize loadings through technologies.
All right, moving on, Teresa.
Thank you. Just to follow up on that, so I understand it a little bit better. So if an applicant had a Reg 5, which is a non-discharge permit, I believe, and discharging into a Tier 3 water body, the anti-degradation review and implementation would not be required. Is that correct?
Yes. Wait. If the anti-deg would not apply to a Reg 5 permit because it's a non-discharging permit, the way they're set up.
Even though they may require an NPDES permit? Do I have that incorrect? I thought some Reg 5s required an NPDES permit.
No, not Reg 5 is Reg 5 in Arkansas is not an NPDES permit. And
okay.
And those farms you're referring to, those liquid animal waste systems, may be permitted under appropriate Reg 5 permits in Arkansas. They are not NPDES permits.
Okay, just to restate this, so if there is a new confined animal feeding operation that is under Reg 5 and not Reg 6, and discharging or not discharging, but is in proximity to and applying manure close to a Tier 3 stream, the anti-degradation review and implementation would not apply to that situation. Is that correct?
Right, because they're not allowed to discharge.
Theoretically. Okay. All right. I think that's a giant loophole in this process. So just please note my concern about that.
Okay.
We're all caught up on the chat comments. Any other comments or questions? Colleen.
This is kind of on a theme. On page 8 of the AIM, on renewals, what is subject to review or not, and it says they will not be subject to AIM review if there are no proposed changes which would result in significant increases of pollutant loadings. So, that kind of, to me, is different than the definition under activities where it says proposed new or expanded NPDES permits. It seems to apply some level of expansion. So is there a difference between what says on page 8 and the definition of activities to which this applies?
Where were you I missed part of the beginning of that where you were reading from.
Page 8, activities eligible for anti-degradation review.
Okay.
Under renewals. Again, it's, back to my question about shouldn't we be looking at renewal of existing permits, but this is even beyond that. It seems to qualify what expanded loads get reviewed because it says significant increases in this. So what qualifies as a significant increase in loading that requires anti-degradation review?
Hey, Brian.
Yeah.
I don't know if this fully answers it, but if memory serves me, I think one of the reasons that was in there, in the way we evaluate industrial discharge, they aren't evaluated on design flow. They're evaluated on production. And our permit engineers have a way to evaluate production to determine whether or not it's significant. So an actual change might be occurring in the facility, but when we don't consider it significant, we in essence don't change the permit limits. They might say, oh, our production went up and our production went down, and we run it through the calculations and we determine that it is by our definition not significant. We don't change those. So in essence, you're not having any change in load. And that was my first thought when I saw that. If that's probably what that's talking to. That's not to say that shouldn't be kind of cleaned up or clarified. And there might be some additional significant change that it's referring to.
I think that would be helpful, some further consideration on this. And I think an argument can be made that any increase in pollutant loadings, and if that's industrial permit where it's an increase in production, that should trigger the review. You know, I also have a question about basing municipal permits come up for review where their original permit limits were based on, you know, the facility design loadings, and yet they are just their actual flow is well below the design flow. And, you know, so when those permits are reviewed, I think there's an argument to be made that they should go through degradation review because we don't want to degrade our existing high quality waters. And if they've been discharging at half of design flow, then there should be a review of what's going to happen when they go up to the flow at full design. So that's
a legitimate question.
You know, it's a different approach. I'm sorry.
Yeah, no, first, Carrie, I'd forgotten the details of why we put each word in those definitions, so I appreciate that comment. But to that last point, just to clarify, well, first, the comment, I understand and appreciate the perspective, but just to clarify, we had intended the review to trigger and apply to increase load when compared from permitted potential to future permitted potential. So it wouldn't apply if someone was running a facility slightly under design flow. But no, I can certainly see the point being made. That's just kind of where we landed today, but we'll consider that comment.
Thank you.
Excuse me. Some additional clarity on the term significant increase in pollutant loading, significant degradation, and significant lowering of water quality would be appreciated.
Okay. Yeah, again, it may be related to some of Carrie's discussion about having, or at least having a definition that would fit any possible scenarios that may come up, but we can look into it.
I think the significant lowering of water quality and a significant degradation were more specific to whenever we're doing that, looking for that 10%.
Good point.
The similar capacity. Those definitions in particular, I think that's what those were for.
We're caught up on questions and comments in the chat. Anybody else have any questions or comments? We'll go to Teresa.
Thank you. One last suggestion for our next meeting in a couple of weeks. I think what would be very helpful to me and possibly to other folks is that You know, many of us have made a lot of comments today and in previous meetings. And if you all had time, if ADEQ had time to go through and place those comments in each section, just so we have a running tally of things that you're going to respond to or consider. So I guess what I'm suggesting is, like, for example, 5A, in section 5A, if there was a comment made under that section, that you all could make a note underneath there, maybe in red, or if you've made any revisions, you could make a red line revision that we could have prior to our next meeting. I just think it would help us get further down the road a little bit and have more substantive conversation. Thank you.
Thank you.
Thanks, I appreciate that. We can try to compile, and we continue to compile, by the way, the meeting notes and comments, and in some form, we plan to document each of these notes, but we'll see what we can do, especially by the time of next meeting. But good comment.
Brian, this is Russell. I just want to, I may be beating this to death, but I just want to make sure I understand some of your prior responses in reference to a discharger that is under design capacity on a tier 3 water. Now, are you saying that they are not allowed to increase, even temporary is, we allow that, but are they allowed that 10% or not?
They, under this plan, as it stands, they are not allowed a permitted increased load.
Okay, that's what I thought, and that would be consistent with what we would recommend. So just wanted to check. Thanks.
Yep.
Colleen.
I just would like you guys to check and then consider in terms of what some of the prior stakeholder comments were about non-point sources. In 40 CFR 131.12A2, the last sentence before you get to the smaller subsection says, further, the state shall assure that there shall be achieved the highest statutory and regulatory requirements for all new and existing point sources and all cost-effective and reasonable best management practices for non-point source control. And this is the section on the 131.12 is the anti-degradation policy and implementation section method. So it does seem to me that there needs to be something in this policy that talks about, Reg 5 review, that all cost-effective and reasonable best management practices for non-point source control are in place.
Sure, and then we do understand the perspective, and we'll certainly consider the comment. It's not lost on us. We did spend some time on that, and we'll continue to spend some time on that. So I can just say for now, we acknowledge the comment.
Thank you.
Russell.
On that point, 131.12A2, it does not require a state to establish BMPs for non-point sources, but EPA interprets that same reg as requiring states to adopt an anti-degradation policy that includes a provision that will assure that cost-effective and reasonable BMPs established under state authority. And that actually goes all the way back to 1994. So there is a clear requirement for that in anti-degradation implementation.
Yeah, no doubt, no arguments here. It's that assure that, I guess, it remains up for some discussion when many of those programs are managed by entities other than Department of E&E. So that's just an area, like I'd said, we'd spend a lot of time on, and we'll continue. But definitely good point, Russell.
Okay, thanks.
We're still caught up on the chat. Is there any other comments or questions?
All right. This is not a last call if somebody comes up with something, but I was just going to speak a minute on the next meeting. Like I mentioned before, we're looking at, let me make sure I got my dates correct. We're looking at July 21st. We don't have a time set, but we anticipate it would be about 3 hours and largely up to more open forum and discussion. Just for now, I anticipate we would bring some high points to the table. Some of the key items brought forward, I don't know if we need to discuss them all in greater detail or not, but we can certainly walk through at least a short summary, if not more. But the point of the last meeting for now, as we're planning, is to provide more open forum or more opportunity to bring more discussion to the table. But really, what I would like to do is, I guess, task everyone to go back and review the CPP and the anti-deg implementation methodology in their current draft forms. Think through it, compile any more discussion items you may have, and if you have any, prepare to speak to those at the next meeting. But if you have any suggestions as far as formatting or major items for discussion for the next meeting, feel free to email that to the email address that we had provided and is on the website. But meanwhile, we'll be planning for the last meeting, and we'll be providing a schedule and information as we move closer to that, as it will be on July 21st. But I guess for now, I can call last call for today's comments. Any thoughts or any other items? Go ahead, Colby.
So there was some comments. I don't remember who brought it up, but I did receive additional comments in the chat about the link not working on the website, and we have confirmed that it didn't work, and we are aware of that. It did have the correct meeting ID number and everything. We're not sure where the disconnect is, but we will be looking at that, maybe just possibly displaying the meeting ID number for you to go to zoom.us and type in that meeting ID number. But we will work on getting that link or making it convenient to be able to, from our website, getting from the website to this meeting for next time.
Yeah, and that's a good point, Colby. I hate to hear that something didn't work. I know we copied that straight from the same meeting invite that we had sent around to ourselves, and they worked, but I apologize for that, and we'll figure out a better way to get that out there. But meanwhile, our staff internally will be preparing for the next meeting, and if there's not any last minute thoughts from anyone, we're going to get ready to close out. So if there's anything else, last call, I guess. So if not, I'm going to conclude this third meeting, and we'll continue to think through these points, and we'll continue to plan for the fourth meeting, and we'll be providing information as it becomes available. Again, I appreciate the involvement of the stakeholders and those others listening in. I've heard we've got a pretty large group at this point. Appreciate the work of DQ staff, and we'll be providing more information as it comes out. So with that, Colby, unless you have anything, or Carrie or Zachary, I'm not hearing anything, so I'm going to close out today. What was that, Colby?
I said all good here, nothing in chat.
Thank you.
I was just
Go ahead.
I was just going to add, we will attempt to be as quick as possible as we can and summarize the meeting notes for today. The comments to include those in the actual documents notwithstanding. We'll get the comments as they stand posted to the website, and a Zoom invite for the next meeting as soon as is reasonable, because that's 2 weeks, and we truly work as fast as we can, but we ourselves don't load it up to the web, so we have to account for that.
Yep. Good point. So with that, I am going to close out today's meeting. But you have our email and you have the contacts from the webpage. If you need anything, please don't hesitate. Otherwise, we appreciate your time spent today, and we're going to close out today's meeting. Thank you all.